Hi folks, for those of you that don't know me, I'm Colby Kanouse and I'm an attorney here at Chuck Franklin Law. Today we're going to talk a little bit about depositions, tell you what a deposition is, what it's used for, and we'll go over some ground rules that'll make your deposition hopefully go a little smoother. So a deposition is a discovery tool that attorneys on either side of a case can use in order to acquire information regarding the other party's claims. You can depose parties, you can depose witnesses, and what you're doing when you do a deposition is basically just trying to learn as much as you can about the other side's position and what evidence they have to bring to trial. So a deposition is one tool to do that. And when you do a deposition, basically what you're doing is you're summoning a party or subpoenaing a witness to come in and to give you testimony under oath in front of a court reporter. And it's the same oath in a deposition that you would be under if you were testifying in court. You're just in a slightly less formal setting and there's no judge there. So the court reporter, she writes down everything that's said, and because of that, it's important that people observe rules that they wouldn't really worry about in normal conversation. Probably the biggest one is we tend to say uh-huh and a lot, and that doesn't fly in a deposition. Everybody understands what you say it when you do it in normal conversation, but if you do it during a deposition and 6 months later when the attorneys who don't remember if it was an or an go back and try to read the transcript, they're not going to know. And rather than spend 2 years fighting over whether something was an or an it's a lot easier just to correct a person if you're in a deposition. So if you're in a deposition and somebody asks you something and you say and they say, is that a yes or is that a no, don't get frustrated. People tend to do it a lot, and sometimes people get frustrated because the attorney or someone in the room keeps saying, is that a yes, is that a no? Just keep in mind, the reason they're doing it is so that the transcript makes sense later. And if you get a good transcript, odds are you won't get summoned back to testify in court because the attorneys can read in your deposition transcript. So it's important that you follow that rule. In a similar vein, if someone asks you, how big was a certain object, and you say, oh, it was about this big, they're going to know what you're talking about that day, but they're not going to have a clue what that means when they go back and look at the transcript. And so they may say, so about a foot or a foot and a half. And again, they're not trying to suggest an answer or give you a hard time. They're just trying to be mindful of the fact that the goal of the whole deposition is to get a usable transcript at the end. Another issue that comes up a lot of times is people tend to talk over each other. In a normal conversation, that works because one person knows what the other person is saying before they're done actually saying it. And you can't do that in a deposition. The court reporters will get really mad at you if you do, because they can only write down what one person's saying at a time. And so it's important that you observe a pause. The biggest thing in a deposition, if you're sitting for one and you're being deposed, is to answer the question that's asked. But that requires you to do several things. First, you have to listen to the question. You have to comprehend it. You have to make sure you understand what the question is and what they're asking for. And if you don't, it's really important that you speak up and you ask the person to rephrase it. You know, as attorneys, we tend to ask a whole lot of questions. It's our job. And when you ask that many questions, you inevitably ask some dumb questions. You ask some questions that are poorly phrased. And so it's really important that the witness, whoever it is that's being deposed, understand the question. And if they don't, it leads to all kinds of trouble down the road. So if you don't understand a question, please speak up and ask the examiner to rephrase the question. If you don't and you answer it, everyone's just going to assume you understood it, and that could look bad later. Another thing that comes up a lot is people get nervous. Most people haven't been in that many lawsuits, and most people haven't sat for a deposition, and so they tend to get nervous. And what happens when people get nervous is their mouths run, and they never stop running. And you know, us attorneys don't like that because that's our job. But in any event, you don't need to give more information than a question calls for. So, and again, this goes back to listen to the question, make sure you understand it, and only answer the question that was asked. You can pretty much rely on the attorney to be thorough in their questioning, and if they're not, then they're doing that at their own risk, and you don't need to worry about it. So those are kind of some do's and don'ts for a deposition. There are other videos that explain some other finer points, but those are the things that I see that come up a lot in the depositions that I do.